Case number 130, matter of Yoga Vida, New York City versus Commissioner of Labor.
Your Honor, I'd like to reserve 3 minutes for rebuttal.
Yes, you may.
Thank you. May it please the Court, Elizabeth Harlan on behalf of the appellant, Yoga Vida, NYC, Inc. The issue on this appeal is whether there is substantial evidence in the record to support the Unemployment Insurance Appeal Board's finding of an employer-employee relationship in this case. As this Court is well aware, substantial evidence means taking a look at the record as a whole. And when that's done, the answer is that there is not substantial evidence on the record. And this is true whether the Court applies the results produced or means used test on the one hand, or whether it applies the overall control test on the other hand.
So you think either that it applies, you're correct whether you apply the traditional test or the overall test. The overall test, I thought, generally applied to professionals, lawyers, doctors.
I absolutely agree with you, Your Honor, and I would urge the Court to apply the results produced or means used test.
So that's a traditional test. So let's assume that we apply that test then. Then we're really into what's substantial evidence here, aren't we? Because
Right.
for us, the facts are the facts, and we don't really get into that. So substantial evidence, as I understand it here, is less than a preponderance of the evidence. So that means it would be less than if they had a scale, 50%, but it can still be substantial evidence. That's the way I read Grammaton in those cases. I can see that there are facts on both sides here. I think that that's a very reasonable argument. Violation of substantial evidence becomes much tougher, though, in that circumstance, because there is proof that supports the Commissioner of Labor here.
Well, Your Honor, I would like to just point out a few of the facts that the Commissioner of Labor relied upon that we believe are either incorrect or incorrectly interpreted.
So let me ask you this, and this is a hard question in cases like this. Is there anything you can argue here that doesn't imply, it doesn't require us to reinterpret the facts for the
Absolutely,
department?
absolutely. There's also a slew of facts that were not considered at all. And under Grammaton, we should be, or the Court should be reviewing the proof within the whole record and find that it has to be of such quality and quantity as to generate a conviction in and persuade a fair and detached fact finder. And so if you look at the record as a whole and consider the facts that I'll just discuss in a moment about what was just not considered at all by the board or by the appellate division, it's enough to shift the scale over to find these non-staff yoga instructors to be independent contractors.
You know, when I was at the Supreme Court, the kind of way I view these cases is I'd say, should this question go to a jury? And if the question went to a jury, then I'd say, well, they decided it. It's a factual question. It's not for me to decide it. It seems to be that that's kind of the position we're in right now.
That it's a factual question. It can be considered as a matter of law when the facts are clear enough to meet the burdens, but and I believe it, or we believe it is clear enough in this case.
Go ahead. Go ahead.
So I guess I'll focus on the factors that were not considered. The first one, which we think is the largest, is that the non-staff instructors are free to work elsewhere. They're free to work for competitors, direct competitors. They're free to tell their students who are in the yoga class, tomorrow I'm going to be teaching down the street at this other yoga studio. You can come to my class
How
there.
is that different than someone who works in a part-time job at 7-Eleven, then they get another part-time job at McDonald's?
Because I think it has to do with what these individuals do. They are they're entrepreneurs. They're building a business for themselves, and they want a following to go from place to place.
Was there any testimony from those type of instructors in this case?
There's no testimony on the record from the instructors. There are websites and there are business cards that
No,
show.
but it was enlightening to me. I think there were 2 letters from whoever was running Yoga Vida, but the one in direct response to the commissioner, I thought was nowhere near as enlightening as the second one after the ruling went against him, because it seems to me that kind of what the point you're making now was not as clear, that it's the instructors who don't want to be employees. I mean, they want a space, but maybe they don't want to work other than Saturdays, or maybe, you know, and they have the following, the gym doesn't, the space doesn't have the following, right?
Right, exactly. The instructors have the following. I believe that Michael Patton did provide testimony to that effect to the administrative law judge. You're correct, it does not appear in his initial letter answering the department.
Well, the students are people who go to Yoga Vida, correct?
Among other places.
Yoga Vida has to permit them on the space, do they not? So they're not really students in the way you're suggesting, clients of the instructor. Because if Yoga Vida won't let them in the door, that student is not going to be in front of that instructor, correct?
You're correct, Your Honor. They are not clients, but they are people who want to take the class of this individual instructor. And the website will say who the instructors are.
But it's not like what you're sort of suggesting, I think, is that these instructors have this business going and they have a following of students, and the students just go wherever the instructor finds a space. But that's not this record. These are people who go to Yoga Vida
Well, the
for
record,
yoga classes.
the record reflects that the judge, sorry, I apologize, that the instructors do teach at multiple locations. And that they do choose to do that. It's important to note that there are instructors at Yoga Vida who are employees. Approximately 75% of them are employees. 25 are these independent contractors who have chosen not to be employees and instead to be free to teach at the United Nations and to teach at companies and to teach at Yoga Vida and to teach at, you know, other yoga studios, all kind of at the same time. They're not downtrodden individuals. They're entrepreneurs building their own business, and their websites do reflect this.
Do we, or did the commissioner or the ALJ consider that Yoga Vida is in the business of giving yoga classes?
Yes.
So that's their business, and so wouldn't that have something to do with whether these folks are considered independent contractors or not?
I agree, it does have something to do with it, but to make that the end-all, be-all factor would destroy the ability to have independent contractors in certain industries as a matter of course, and that wouldn't be
Well, you see the policy
beneficial.
implications
There's
of the question.
There are policy implications on the flip side. I'm sure we'll hear from the Commissioner of Labor about the policy on the one hand, but on the other hand, there are a lot of people who benefit from being able to be independent contractors and go from place to place. There are industries like dentistry and, you know, gardening and yoga and places, people that do benefit from being able to, while they do the core work of the business, they want to do this in an independent contractor capacity.
What's the benefit?
The benefit to them is that
The freedom, I get your point there, freedom to go, but what, financially, what's the benefit?
well, they can grow their business. They can make more money going to more places than they could working in.
Because they'll work more hours, or what's the?
More hours, more diversity. They could be a dancer, they could be an actor, they can choose to do, sort of design their life the way they want to. If you look at the websites, or if you look at the Yoga Vida website, you'll see there are a number of these individuals who have blogs, who are, they're creative individuals. And
Is any of this dependent on the expertise of the commissioner with respect to what the market looks like and what trends there are in labor? Is that anything that needs to be considered in this case? The deference in that way, not just on the substantial evidence standard, but deference to the commissioner with respect to the way the commissioner views the market and these labor trends and employment trends?
Well, Your Honor, I would say that on the facts of this case, if these individuals are considered to be employees, it will shut down a lot of, it will potentially cause individuals to lose their jobs. That's the flip side of the argument, because this yoga studio cannot afford to employ this many people. And they have their core employees, and then they have these individuals who come in and teach 2 weeks or teach one workshop. And they won't be able to employ them, so those people won't have a job anymore. So I don't think it's a one-sided, independent contractors are always bad type of argument.
Thank you, counsel.
Thank you.
May it please the Court, Valerie Figueredo for the Commissioner of Labor. The Board properly concluded that Yoga Vida's non-staff instructors were employees of Yoga Vida for payment of unemployment insurance contributions. The Board's determination was based on its finding that
Could a yoga
Vida...
instructor ever be an independent contractor?
In the context of a school that provides yoga instruction to that school's clients, we believe that it would be highly unlikely for the yoga instructor that furthers that core function to ever be an
So
independent
that's what
contractor.
makes the difference, that this is a yoga studio and nothing else.
It is the fact that this is a yoga studio, and Patton testified that providing yoga instruction is an integral function. It's the sole basis for the school's revenue.
So
is
if it
compelling.
was, let's say, a gymnasium that had weights, has other classes, yoga is one of those classes that they offer, would those yoga instructors then be independent contractors as opposed to employees?
Certainly where the gym exercised the level of control that Patton exercised here, you would find that they would be employees.
But they can
The
work for competitors, right?
The non-staff and the staff instructors
No,
can.
no. The ones that we're talking about, the ones that they say are independent contractors and you say are employees, up until the time you make that determination, they can work for a competitor of Yoga Vida.
Yes, the
right?
non-staff instructors can
And yet
work.
you're saying, well, you're still an employee even though you can work for an opponent, a competitor.
There's certainly lots of industries where you have people enter into multiple employment relationships. We cite one example in our brief where you have the lawyer who's an employee of the law firm and then also an employee of the university where he might teach as an adjunct professor.
They're not competitors. You can't come to my law firm and work for let's say a plaintiff's law firm who is suing somebody who's insured by State Farm and then go, on their weekends and work for State Farm's law firm.
Sure, that may be an ethical problem.
It's not an ethical problem. I mean, it is, but it's a problem that no one's going to counter. And what my understanding of this is that you have people, as your opponent is pointing out, who, for a variety of reasons, only want to work certain times. I don't know if they're actors or whatever else they're doing, but they can do this. They can do it in evenings, or they can do it on weekends, and they want to be able to do that. And if one gym can provide Saturdays and another one can provide Sundays, they want to do both of those. You're saying they can't do that, that they are an employee of Yoga Vida, that that's it, and they can't work for a competitor.
We're not saying that they can't work for a competitor. Certainly, you can enter into multiple employment relationships, even with a competitor where the employer permits you to do that. The flexibility, the fact that you can work for multiple competing businesses is just dictated in the confines of that relationship. It's not required. It's not something that we're saying is part of the rule. What we're saying here is that where you have a gym or where you have a business whose function is to instruct students, such as in this case yoga, but in other contexts such as music instruction or gym.
But if a person is working at Yoga Vida and then working for a competitor, who's paying the unemployment insurance and who's paying all of the
Right.
things that you say? All three of them, if there's
Yes,
three?
so-
All five of them, if there are five?
Yeah, that is correct. The threshold for payment of unemployment insurance contributions by the employer is low. It's set by the legislature at $300 in a calendar quarter. So once the employer pays $300 in wages, he's required, or it's required to make those contributions. If you are seeking benefits once you are unemployed, it is your prior employers in a four-quarter period, in the preceding 4 quarters, that would be required to pay out, or from whose funds those unemployment benefits would be paid.
Counsel, I'd like to go back to this integral to the core business argument. And that's something that Appellate Division mentioned. They cite this Appellate Division case. You have a substantial point in your brief on. We've never held that, right?
Right.
So how much is it your core argument that we need to find that? I mean, it seems like if we do that, that kind of swallows up the rest of the test, right? Because you would say, hey, this is integral to the core business of a yoga studio. They have to be employees. And we've never done that.
It's correct that the court has never specifically held that the integral function is one of the elements. It is elements that, as we cite in our brief at pages 28 to 29, various courts have considered. We think it is a compelling indicator of employment. You certainly are not going to be, it's unlikely that a business will cede control over its core function to an independent contractor, because as we explain in the brief, it is upon that core function upon which the business relies. So it's certainly a compelling, if not determinative factor of employment. Here, you don't have to decide. You don't have to just look at the core function, because we know that Yoga Vida exercises meaningful control over other elements of its relationship with its instructors.
Well, Ms. Harlan makes the point, I guess, that is it 3/4 of them are employees and 1/4 of them are not?
The testimony we have is from 2011. At that time, Patton testified that 25% of its instructors were independent contractors. They were offering approximately 95 to 98.
So the answer is yes.
Yes.
Because I was going to follow-up question was, did the 1 quarter, did they complain? Are they upset about this?
We do have, it's not in the record. There are...
Well, in the record, I found no one complaining. And in fact, I thought the testimony was that they want to be free to advertise, to do, as Ms. Harlan saying, to blog, to solicit, to do what they do in terms of what they determine as yoga, and they don't want to be an employee.
There's no evidence in the record about what the individual supposed independent contractors want. The only testimony we have is from Patton. What we have in the record are printouts from websites and business cards showing that these independent contractors had outside businesses. It does not prevent them from having, you can be in an employment relationship with Yoga Vida and nonetheless run your own yoga business on the side.
I know, but my point was, no one's complaining.
No one is complaining in this particular context because this arose out of Yoga Vida's registration through the Department of Labor. We do know, it's not in the record, but we do know that there are yoga teachers in the industry seeking unemployment benefits.
To Ms. Harlan's point about Yoga Vida being in a position to perhaps want to have a few independent contractors, what would the structure have to be in order for Yoga Vida to do that?
You could certainly imagine a situation where Patton did not monitor the quality of the instruction. So for instance, we know here that Patton, Yoga Vida itself is the one that takes the students' complaints, and Yoga Vida then investigates those complaints. So you could see a scenario where Yoga Vida doesn't accept complaints, it's given directly to the instructor. You could have a potential scenario where the instructor himself or herself sets the class fee and collects the payment, so provides the administrative responsibilities that Yoga Vida was taking on. Here we know that it's Yoga Vida who sets the fee and Yoga Vida collects that from the students. You could potentially see a scenario where Yoga Vida just rents out a space and collects a flat fee from the instructor. We don't have that here.
So these are Yoga Vida students or Yoga Vida clients?
That's correct.
These are not individuals who are students of that particular instructor? Is that what you're trying to say? I mean, it is possible, as she's argued, that someone follows that instructor knowing, oh, they're going to be at Yoga Vida Monday at 8 a.m., I want to do that class.
It is possible, but what we have here is Patton's testimony explaining that it was Yoga Vida, for instance, who provides a substitute when the instructor cannot teach. And why does Yoga Vida do that? Because it is in Yoga Vida's interest to not have the class canceled, because it is Yoga Vida's business and brand that they're trying to protect. It was Yoga Vida who monitored the quality of those instructors and set the fee for the classes.
And if I'm one of these Yoga Vida non-staff instructors, and I have Monday at 8 a.m., I can't tell Yoga Vida, I have 2 students who are coming, and those are my students. I don't want anyone you want in here coming into my room.
That's correct. Patton was not asked that hypothetical in the testimony, but it is clear that the way they advertise for classes, which is by posting the weekly schedule on Yoga Vida's website, is to try to attract people who are looking to go to Yoga Vida, not necessarily a particular instructor.
Counsel, how is this different from the building industry, for example? You have a lot of independent contractors. You have plumbers and carpenters, but the basic idea is to build something. And those are independent contractors. Why is this different than that?
Putting aside the Fair Play Act, which creates a presumption of employment for certain, in the construction industry, for certain types of individuals, here this is different because in the construction industry, when you're bringing in a plumber, that's your classic independent contractor situation where they're providing their specialized expertise to deal with a particular problem. Here you have a business whose sole function is to provide yoga instruction, and they're trying to delegate that sole function to people they claim are independent contractors without ceding the necessary control to really give those people true independence. If there are no further questions, we believe the board's determination should be affirmed. Thank you.
Thank you. Ms. Harlan?
I'd like to clarify that Yoga Vida, in addition to yoga instruction, also trains teachers to become yoga instructors, and they also lead trips. They take retreats. They take students on retreats. So yoga is not their sole source of income. Also, Mr. Patton does not monitor the quality of the classes. He doesn't sit in classes and watch the instruction. He doesn't tell the yoga instructors how to instruct the class.
Yes, but if I'm one of the non-staff yoga instructors, and I have a student who's as you were arguing, follows me and looks for my classes, Yoga Vida could choose not to let them take the class, correct? Because they make the choice about who walks into their studio and stays, correct?
That's correct. Yes. I'd like to clarify the issue about the substitutes. Yoga Vida asks the independent contractor to find their own substitute, and that is in fact a sign of freedom, not a sign of control. And they find their own substitute. They don't have to tell, the only reason that they tell Yoga Vida is so that the website can be correct.
If they don't find an instructor, what happens? The class is canceled?
That's a good question. My understanding of the record is that if it's right before class, like 30 minutes before class, that's when the staff will come in and teach the class. Otherwise, my understanding is the class would be canceled. And that testimony is at A132.
And could an on-staff instructor persuade a staff instructor to be the substitute, or does it have to be someone else?
It could be a staff instructor. I'm sure that would be fine. With respect to I think the court's already discussed this, but this core.
So let me just ask.
Sure.
So the substitute, when they come in,
Yes.
need not teach in the same way that the non-staff teaches, right?
That's right.
So
They
the
would-
non-staff could be, whatever, I'll make one up, Burkham. But that's not what the substitute's going to teach.
Well, Your Honor,
Is that correct?
I think that the substitute needs to teach the class the students are expecting to receive, whatever type
So
of
if
class.
it was listed, so then Yoga Vida chooses the type of yoga that gets taught at a particular hour?
No, the instructor chooses what they're going to teach. There's a discussion at the beginning of the relationship where the instructor says, I teach this and that. I need approximately this much time to teach my class.
So Yoga Vida doesn't say, well, you know what, I want a few instructors who are doing Burkham. I'll hire you.
Though that may be the case as long as they really do Berkram.
Your opponent makes a compelling argument on the core function issue. Do you care to?
I would
Press
like to
that
speak
further?
to that. The core function argument has never, as the court said, has never been adopted by this court. It seems to have been taken out of the federal standard, the FLSA standard, without the other factors being brought in at the same time to sort of balance it out. And if it's adopted by the court, it would largely swallow up the analysis.
Is your position that the approach they've taken is a single-factor test?
I don't think they're saying it's a single-factor test, but they're saying it's a very important factor.
So but in the federal approach, it's a multi-factor test.
It's a multi-factor test,
And
absolutely.
that seems to have worked, right?
In the federal setting, but it hasn't been applied by this court. I think my time is up.
Thank you, counsel.
Thank you.